Gladys.
Okay, so good morning and good evening to those who are based in the US, abroad. Thank you for joining us today to discuss the important topic of genetically modified organisms, or GMOs, and biosafety. I am Gladys Completo, currently the president of PAASE, and I will be the moderator of this fireside chat. And together with me is Vice President Peña. So as we all know, GMOs have become an incredibly controversial issue in recent decades, with much heated debate around their safety for human and environmental health, as well as their important role and impacts in modern agriculture and food production systems. However, the scientific evidence accumulated over the years of research shows that approved GMO crops are not only safe for humans and the environment when properly regulated, but they also offer tremendous benefits that should not be ignored. And examples of GMO crops are the BT talong and golden rice developed by publicly funded research institutions like the University of the Philippines, Los Baños, and Phil Rice. BT talong is an eggplant variety engineered to resist destructive insect pests, reducing the need for pesticides and increasing yields for farmers. While golden rice provides a biofortified source of vitamin A, which can help address deficiencies that cause blindness and increase risk for millions of people, especially children around the world. GMOs like BT talong and golden rice represent an important scientific tool to improve food security and nutrition while enhancing farmer livelihoods. They can play a vital role in achieving many of the UN's Sustainable Development Goals related to poverty, hunger, health, and environmental sustainability. Despite these benefits, these GMO crops have been subject to controversy here in our country. Recently, the field trials or commercial production of golden rice and BT talong were halted by a Philippine judicial court by granting the writ of kalikasan and continuing mandamus petition by environmental and other special interest groups. So let me start with an overview of the case. So let me just share my slides. Okay, so this is the overview of the case where Masipa, Greenpeace, and others filed a petition versus the Secretary of Department of Agriculture and Secretary of Department of Energy, Environment rather, and Natural Resources and other respondents. So just a few facts. The instant case arose from the conduct of field trials for bioengineered eggplants known as Bacillus thuringiensis BT eggplant or BT talong and golden rice. And as I mentioned earlier, golden rice is a genetically engineered rice variety designed to produce beta-carotene, a precursor to vitamin A, to address vitamin A deficiency. Its development and field trials were opposed by various groups like Masipag and Greenpeace, citing concerns over safety, lack of public consultation, and absence of independent risk assessments. And for BT talong or BT eggplant, it's a variety engineered to be resistant to certain pests, and the trials were conducted by UPLB, but they faced legal challenges from environmental groups over alleged violations of environmental laws and lack of studies on safety for human consumption and the environment. And in 2016, the Supreme Court initially ruled against the field trials of BT talong, but later dismissed the case as moot since the field trials had already been completed. The court noted the new JDC 012-2016 had superseded the previous regulatory framework addressing many of the concerns raised in the case. And then after the dismissal, UPLB continued its research on BT talong and applied for a biosafety permit for direct use as food and feed and processing in 2020. Then in August 2021, the petitioners learned that the Bureau of Plant Industry had issued biosafety permits to fill rice and UPLB for field trials, direct use as food or feed, commercial propagation of golden rice, and direct use as food feed of BT eggplant. And in the same year, some petitioners and other individuals filed a petition for review before the DA to appeal the BPI's issuance of the biosafety permits. And their arguments included alleged non-compliance with regulatory requirements like public consultations, lack of independent risk assessments, and claims that these GMOs are unsafe. And in June 2022, the DA Secretary dismissed this DA appellant's petition, stating that the BPI properly followed the procedures under the joint JDC number 1, 2016 in issuing the biosafety permits. Then the petitioners filed this writ of kalikasan petition challenging the issuance of the BSPs and planned commercial propagation of golden rice and BT talong. Then the Office of Solicitor General argues the petition should be dismissed as the requirements for a writ of kalikasan are not met, citing the biosafety assessments that found no significant risk and asserting the BPI lawfully issued the permits under the JDC number 1, 2016. Now, the Supreme Court en banc issued this resolution last April 18, 2023, resolving to an issue of writ kalikasan against the respondents and required the respondents to file verified return of the writ of kalikasan before the Supreme Court within a non-extendable period of 10 days from receipt, as provided in Section 8, Rule 7 of the Rules of Procedure for environmental cases. And in the resolution, SC en banc resolved, among others, to refer the case to the Court of Appeals for the acceptance of the following returns on the writ of kalikasan and for hearing, reception of evidence, and rendition of judgment regarding the verified return of writ of kalikasan filed by the OSG and OGCC. So here's the overview of issues raised by the petitioners. Issues regarding golden rice are the following: lack of genuine public consultation, lack of transparency and access to information, absence of independent risk assessments and evaluations, and lack of comparative studies on golden rice. And the issues on BT talong, environmental groups and other individuals complained that no peer-reviewed study was conducted on BT talong safety for human consumption and the environment. With this, recently the judgment was rendered by the Court of Appeals, granting the privilege of the writ of kalikasan, issuing a writ of continuing mandamus against respondent government agencies, and directing UPLB to cease and desist from commercially propagating and conducting activities relating to BT eggplant under the biosafety permit issued therefore, and revoking the biosafety permit for commercial propagation of golden rice of respondent field rice, and accordingly ordering respondent field rice to cease and desist from commercially propagating and conducting activities relating to golden rice under the biosafety issued therefore. And last, accordingly, CA rendered enjoining the commercial propagation and or conduct of activities relating to golden rice and BT eggplant until such time that the concerned respondent government agencies submit proof of safety and compliance with all legal requirements, ordering concerned respondents government agencies to perform their mandate under the applicable JDC by submitting to this court the concrete mechanisms adopted to monitor all activities conducted under the JDCs and all measures taken to strengthen the risk assessment procedure set forth in JDC number 1, 2021 in accordance with the ruling in this case. And lastly, enjoining any application for contained use, field testing, direct use as food or feed or processing, commercial propagation, and importation of genetically modified organisms until compliance with above is established. With this background, we would like to officially start the fireside chat on GMOs and biosafety, and I would like to call on VP Marj Peña to introduce our first speaker.
Can you put the slides on, Feb? Okay, can we move forward? Feb, can we move the slides? Okay, so good evening, everyone. Good morning from the US, and good morning to everyone in the Philippines. It is with great pleasure that I present one of our panelists today. Dr. Emil Javier is a renowned national scientist recognized for his pioneering work in tropical agriculture research and crop production. His groundbreaking contributions span agronomy, plant breeding, seed production, management of tropical grasses and legumes, and utilization and grazing management of native Emperata graceland. Holding a BS in Agriculture from UPLB and an MS in Agronomy from the University of Illinois and a PhD in Plant Breeding from Cornell University, Dr. Javier's expertise lies in genetics, agronomy, and plant breeding. Tonight, we are honored to have him discuss this very important topic with us. So without further ado, please welcome Dr. Emil Javier.
Good morning to our colleagues in the Philippines, and good evening to our friends in North America. Thank you, Marge, for that introduction. Let me begin by joining the rest of us in congratulating our fellow member, Michael Puroganan, for that distinction of being elected to the United States National Academy of Sciences. I hope Michael is with us. Congratulations, Michael, for a well-deserved recognition. To provide more background to the discussion at hand, I had my staff prepare some milestones in the saga of biotechnology in the Philippines, to add to the introduction made by President Gladys. Please go ahead with the slide. Hello, Rhea. Okay. The usual point of reckoning in the history of biotech in the Philippines was the establishment of the National Institutes of Biotechnology and Applied Microbiology at UP Los Baños in 1979 by the Board of Regents, with funds provided by the Ferdinand Ederlin Marcos Foundation. This is quite significant because from the very start, we had full support from the highest official of the land in the person of the president himself when he committed his own foundation to the establishment of the Biotech Institute in Los Baños. But note that the title is plural, National Institutes of Biotech and Applied Microbiology, because it was very clear from the point of view of our president then, Odi Corpus, and the Board of Regents, that this institute in Los Baños clearly was for food, agriculture, forestry, and applications. And so we needed more institutes of biotechnology in the rest of the UP system. However, it took a while, so that came to pass only in 1995. That's 16 years later, when the network of molecular biology and biotech institutes in the UP system was established by Presidential Proclamation 526 by President Ramos himself. Next, please. The next milestone is 1990, establishment on the National Committee of Biosafety of the Philippines by executive order of President Cory Aquino in 1990. And 12 years later, the Department of Agriculture issued Order Number 8, Series of 2002, on the regulations on the importation and commercialization of GMO plants and plant products. And having issued the DAO 8, that provided the basis for the approval for commercial use of GM corn in the Philippines, which was first in Asia in the same year, 2002. Four years later, by executive order of President Gloria Macapagal Arroyo, the National Biosafety order was issued by GMA. And 6 years later, as pointed out by President Gladys, the Supreme Court issues the writ of kalikasan against the proponents of the BT eggplant. And after 3 more years of appeals and litigation, the Supreme Court permanently enjoined the field testing of BT eggplant and further declared that Department of Agriculture Order Number 8 was insufficient and therefore null and void until a new administrative order is promulgated under the law. But after a year, I think the entire Supreme Court membership saw the light and reversed themselves in ruling against Department Order Number 8. And they dismissed the petition on the ground of mootness, 180 degrees turn. I think it's 12-0 or 15-0 and 0-15 either way. But very importantly, in the fine print, the Supreme Court admitted that it should not have acted on the petition because resolving the petition for the writ of kalikasan would unnecessarily arrest results of further research and testing on BT talong and even GMOs in general, and hence tend to hinder scientific advancement on the subject. I'm calling this out because if you read very closely, they dismissed the petition on the ground of mootness because the tests have been completed. But very, very important is this fine print, because I recall it was now Senior Associate Justice Marvic Leonen who very, very clearly pointed out that, in fact, they should not have acted on that petition from the very beginning because they realized that they're going to hinder progress if they did that. Anyway, the same year, after being told by the Supreme Court, we had a series of meetings, and instead of just the Department of Agriculture being involved, we involved the OST, DNR, DOH, and the local government, and issued a joint department circular number 1 series of 2016. So now it's almost 1/3 of the cabinet were involved, and the provisions were even made more strict and updated to the global standards in GMO assessments. And a little later, 5 years later, in fact, there were further revisions to make the joint department circular on GMOs even more robust and strict. So now we are on this year, a branch of the Court of Appeals issued a writ of kalikasan and a writ of continuing mandamus against Phil Rice and UPLB for commercialization and continuing activities related to golden rice and BT eggplant. Next, please. The writ of kalikasan, for those who are not familiar with Philippine legislation, is a legal remedy under Philippine law that provides protection of the people's constitutional right to a healthy environment, as outlined in Section 16, Article 2 of the Philippine 1987 Constitution, which states that the state shall protect and advance the right of people to a balanced and healthy ecology in accord with the rhythm and harmony of nature. It's a very well-meaning, elegant prose, but later on we realized that this is too susceptible to all kinds of interpretation, which has no bearing with reality. So, for example, the practice of agriculture and medicine will not qualify. The natural vegetation of the Philippines is tropical rainforest, except in the mountains. But we have cut all these rainforests to create farms to plant food crops. So the cutting of forest and conversion to agriculture would violate the right of Filipinos under the writ of kalikasan. The parts of the life cycle of some kinds of worms are in the guts of people and livestock. And medical practice, we prescribe antihelminthics to get rid of these parasites in our guts. And to highlight the unrealness or perversity of interpretation of this provision, let me read verbatim the proceedings in the previous proceedings, where the Court of Appeals rejected BT Talong. And I quote, I don't remember which justice wrote this. There is a perfect and sound balance of our diversity as created or brought about by God out of his infinite and absolute wisdom. In other words, every living creature has been in existence or has come into being for a purpose. So we humans are not supposed to tamper with any one element in this swirl of interrelationships among living systems, among living things in our ecosystems. BT Talong is a technology involving the deliberate alteration of an otherwise natural state of affairs. It's a deliberate change meant to eliminate one feeder, the borer, in order to give due advantage to another feeder, humans. This is a direct quote. Consequently, the testing or introduction of BT Talong into the Philippines by its nature and intent is a grave and present danger to and an assault on the Filipinos' constitutional right to a balanced ecology. Because in any book and by any yardstick, it is ecologically unbalancing event or phenomenon. So if you take this quote as is, so the rest of agriculture and medicine will fail this test of the writ of kalikasan, because all the while we agriculturists are shifting the balance or changing the balance in favor of the needs of man. So for another example, when you plant corn, in the natural state of affairs, there'll be weeds between the corn plants, which weeds will compete with the corn for sunlight, for water, and nutrients. And so what we do is to get rid of the weeds manually by pulling them out one by one or spraying them with herbicide. Or in the case of in medicine, if you want to get rid of your tapeworms in your intestines, you take anti-tapeworm medication. So this is just to show you how these issues started with this provision in the Philippine Constitution, which protect and advance the right of people to a balanced and healthy ecology in accord with the rhythm and harmony of nature. I think we don't have problem with the adjective healthy, but we have difficulty now in what we really meant by balance. And by this quote, by this associate justice, then you see that most of our problems start with this interpretation that any shift in the balance is a disturb the rhythm and harmony in nature, and therefore violates the rights of Filipinos to a balanced and healthy ecology. Next, please. The other issue at hand, and these are the two sources of our difficulties, is the precautionary principle, which has been enshrined in the 15th principle in the June 1992 Declaration of the Rio Conference on Environment and Development, which says that where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measures to prevent environmental degradation. Next, please. So let's go to the specific issues of the case. In pages 123 and 125 of the decision of the branch number 4 of the Court of Appeals, the reasons for granting the privilege of the writ of kalikasan were, first, by reason of the conflicting scientific views and uncertainties on the risk and effects of golden rice and BT eggplant, potential severe and grave threats to the welfare of the people and the environment arise. So their interpretation after all this hearing and expert opinions is that there's that potential severe and grave threat to the welfare of Filipinos. And as Gladys pointed out, the second reason was the biosafety permits granted to field rice and UPLB were issued without sufficient monitoring mechanisms in place. And thirdly, since the subject GMOs are intended to be planted and distributed to different parts of the country, the third requirement of national impact was met, that there are these possible risks and effects which would have impact all over the country. Now, the reasons for continuing mandamus against field rice and UPLB in pages 128-29. First, the Bureau of Plant Industry and the concerned government agencies have unlawfully neglected to perform their duty of conducting monitoring activities, which, to stress, is essential to risk management. Second, such duties enjoined by the joint circular and the revised joint circular on the applicable issuances to the permits issued in favor of field rice and LB.
Dapat pagtanggol na yan, sa selfie.
And then, well, you can read 3 and 4. Go ahead.
Ang dami namang sulat yan. Paano babasahin?
Okay. The specific reasons on the first argument that the Bureau of Plant Industry and Government have unlawfully neglected to perform their duty of conducting monitoring activities as shown in pages 113 and 114. They contended that the monitoring provision of the joint circular was too broad and general. They acknowledged that there were detailed procedures for securing the biosafety permits, but no such detailed procedure.
Si Cass, pinapromote na yung mudfish technology. Alam siya
Excuse me, please mute your
But no such detailed procedure is provided with regard to monitoring, meaning all the measures are in place up to the point when the seeds of golden rice and the fruits of eggplant get into the consumers. So there's no monitoring of what happens to the consumers when this food get into the food system. And secondly, that the joint circular failed to include a provision on the labeling of GMOs. So these are the two very specific issues that we'll have to
Dr. Javier, I think you accidentally turned off your microphone.
One of the specific reasons for the continuing mandamus, do you hear me now? Do you hear me now?
Yes, po.
Okay.
Yes.
Against specifically field rice was the improper issuance of the permit for the field trial of golden rice in San Mateo, Isabela, for failure to comply with the requirement to have one elective official in the Institutional Biosafety Committee. Because under the rules, there will be an IBC in the community where the test will be conducted. And in actuality, there were 5 members in that IBC in San Mateo, Isabela. One was the first 2 are field rice staff, and the third was the municipal agriculturist of the town of San Mateo. The 4th and 5th are really in compliance with the need for people representing the people in the communities, in the person of a lady, Beatrice Acob, who was president of the Rural Improvement Clubs of San Mateo, and Benjamin Lucas, a member of the Municipal Agriculture and Fisheries Council of the town. Next, please. For our information, Beatrice Acob, in addition to being president of the Federation of the Rural Improvement Clubs of the town, which is the association of rural women, mothers, grandmothers, all half of the population, was also an elected barangay kagawad, a councilor of the barangay. But for some reason, her qualification to the IBC was as president of the Rural Improvement Clubs and not as an elected barangay kagawad. And so the court says that then she cannot be considered as complying with the requirement of an elected official, because when you qualified Beatrice Acob, you cited only her position as Federation, Rural Club Federation president, and not as an elected kagawad. And then, so, I think that's a point that was called out, but for some reason, the court ignored that. But in fact, that is substantial compliance. Moreover, instead of just one elected local official to represent the interests of the community, which was the intent of that provision, we included 2. The Beatrice Acob, who is a head of the Women Association in the town, and a member of the other person was a member of the Agriculture and Fisheries Council of the town. Because under the Agriculture and Fisheries Modernization Act of 1997, such fisheries and agriculture and fisheries councils are established at the national level, at the regional level, provincial level, and municipal levels. So that person who is a member of that Agriculture and Fisheries Council in the town should be able to represent the interest of the community. But the court was really nitpicking in this point. They ignored the substantial compliance, our substantial compliance on the requirement of an elected official in the local BIC to represent the interests of the community. Next. So what are the next steps? I guess obviously we have to appeal for reconsideration to the Court of Appeals and back and later to the Supreme Court if necessary. I am very confident that we will prevail because as I read the reasons for the writ of kalikasan and mandamus, I think they're very easy to refute. So I am quite confident that we will prevail in any case. And then I'm also relying on the fact that even in the first reversal of the Supreme Court, after dismissing the petition on the ground of being moot and academic, the fine print recognized that, in fact, the Supreme Court should not have acted on that petition on the first place on BT eggplant, because that would stop all further research and development and progress on the subject matter. But the second obvious next step is we have to renew our efforts for public information. The truth is we had been complacent since we won the reversal in the Supreme Court. After we have had so much effort in public information, but I think we sort of slowed down after winning that round in this Supreme Court. I think we were wrong. So anyway, we have to go back to our concerted efforts to target schools, the members of Congress, including their staff, the judiciary and their staff. We have been doing this before, but of course the staff and the members of Congress keep on changing. So we have to keep on doing this all the time. But relatedly, the Greenpeace and the posters have changed tactics in a way. And so they have begun really concentrating on the local governments, so that at this point, some towns and cities and at least one province has passed ordinances banning GMOs. So in our public information campaign, we should make a special effort to reach out to the local government units. Another source of strength, which we have not used as much, are the farmer groups themselves. For example, the very influential poultry and livestock industry, after hearing of the CA ruling, was up in arms, because in the ruling of the Court of Appeals, they did not only proscribe the commercialization of golden rice and BT eggplant, they also ordered the cease of all movement of all GMOs, which of course would include GM corn and GM soybean. So we don't grow hardly any soybean, so all our soybean are GM, and a third of our imported corn are, one third of our corn are imported, and they're of course GMO as well. And finally, as pointed out by Joel, we really have to seek counsel from members of Congress and judiciary on the further need for specific legislation and regulation of GMOs in an interpretation of the writ of kalikasan. In the first place, the constitutional provision for the right to healthful and balanced ecology was not operable. And so the legislation was needed, but no such legislation was forthcoming. So the Supreme Court took it upon themselves and invented the writ of kalikasan. So maybe time has come for us to come forward with specific legislation on how that writ of kalikasan ought to be interpreted. So that's all I have, and I look forward to participating in the discussion. Thank you, and good morning and good evening.
Thank you very much, Dr. Javier, for that very thorough discussion of the rules and the history of all the of GMO research in the Philippines. And so at this point, we would like to introduce our second speaker, and then we can open up our discussion after the speakers, he presents his talk. And so it is my great pleasure to introduce our next panelist, Dr. Joel Cuello. Joel was recognized for his significant contributions in sustainable biological and agricultural engineering systems, which provides the platform for engineering designs in various agricultural and biological systems, with emphasis on optimizing biological and agricultural productivity while fostering resource sustainability and environmental protection. Among his outstanding works are algal bioreactor systems used in industry, a hybrid solar electric lighting system for crop production in regenerative space life support at NASA in phytometric systems. Since 1996, Joel has served as lecturer, visiting professor, and advisor to graduate students and has provided valuable advice in the improvement of graduate programs and program accreditation in various universities in the Philippines. He has also served as a technical advisor to the Philippine Congressional Commission on Science, Technology, and Engineering, or COMST, the Commission on Higher Education, the Department of Agriculture, and the Department of Science and Technology. So please welcome our next panelist, Dr. Joel Cuello.
Thank you very much, Marge. Let me share my screen. Okay. So I have to say, I'm really honored that I'm on the same panel as Dr. Javier. And you may be wondering why I am on this panel since I'm in engineering. So my degrees, graduate degrees, are master's and PhD in agricultural and biological engineering. But because I was working with cell cultures and organ cultures, I really felt the need to be able to understand genetic engineering. And so I decided to get a second master's in plant physiology at Penn State. And then after that, while I was an assistant professor at the University of Arizona, and even now, I still work with genetically modified organ cultures or cell cultures that I grow in bioreactors. So I have understanding of genetic engineering, but that is not the reason why I'm here. I'm not here as in terms of my expertise in genetic engineering per se, and I've never been involved in the studies for BT eggplants and golden rice in the Philippines at all. But I'm knowledgeable enough to help in terms of collecting pertinent facts to put together a strategy, scientific strategy or legal strategy, if you will, for the Philippines in terms of advancing genetically modified organisms in the country going forward. So that's the spirit of my being here. So I'm not going to have a long presentations. This will be quick. And I listed here a number of, I'd say, nuggets or information that I think would be helpful in all of us together, coming together to discuss and to consider in terms of, again, putting together effective strategies forward for the Philippines. So I want to point out that this GMO Biosafety General Standard, which is adopted by the U.S. Food and Drug Association, or administration, sorry. So foods derived from GMOs must be demonstrably as safe as the non-GMO foods one eats. So I picked this out because it's a very simple statement, but it's really a powerful standard, scientific standard, as well as legal standard in terms of evaluating and assessing the biosafety of GMOs. It's always in comparison with the non-GMO food that one eats. And it's demonstrably safe. So I mean to say by demonstration through experiments or other studies. And I think it's important because as Dr. Javier pointed out, with the Supreme Court, receiving conflicting views in terms of the safety of GMOs, they have nothing to go with in terms of law. And so they're kind of forced to invoke, for instance, the writ of kalikasan, which really is not practical as a legal standard because it's absolutist in its spirit. And so it's unattainable, really. Practically speaking. So it's important going forward to work with the legislators in the Philippines and the executive branch as well, and hopefully with the judiciary as well, to pass a law regarding GMOs in the Philippines, and then setting by law this practical standard of how to evaluate its biosafety. And that is always in reference to the non-GMO counterpart. Trying to advance my slide, but it's not advancing. Bear with me. Oh, there it is. All right. And this is very true that there is broad consensus on the GMO safety or biosafety. And this is a statement from the National Academy of Sciences of the United States. There are no data to indicate that consumption of currently approved and commercialized GMOs is bad for human health. And really, this consensus is shared not just by the members of the national academies, but also by other scientific bodies in many parts of the world. Over the 2 decades that GMOs have been on the market, and that's especially true here in the United States, there have been no occurrences of health issues due to genetically modified organisms. So that's a general statement, and that is true. Comparing genetic engineering as a method versus other plant breeding methods. And I brought this up particularly with induced mutagenesis. So one way to create mutation or changes in the genes really is by exposing cell cultures, for instance, to radiation or chemicals. And that's how you can produce those mutants, for instance. However, despite the foregoing method, the induced mutagenesis being less precise than genetic engineering. So in other words, when you compare the methods of genetic engineering of inserting gene into the genome of cells of plants or crops or animals, that is a much more precise method compared to induced mutagenesis. And yet the irony is that crops that are developed through induced mutagenesis are not subject to regulations or testing. But GE crops, of course, are subject to regulations and testing. Here's another fact. Millions of people eat genetically modified foods. GM crops today are now grown over 160 million hectares in 29 countries. GM crops are imported by countries, including European ones, that do not grow them. And I pointed out the European countries because most European countries are averse to genetically modified organisms. In fact, they don't like it. It's illegal for them. Nearly 300 million Americans, 1.4 billion Chinese, 280 million Brazilians, and millions more elsewhere around the world regularly eat GM foods directly or indirectly. And this is a fact. Now, back to Europeans. Though Europeans voice major fears about GM foods, the EU permits GM corn cultivation. Now, some countries within the EU, they still won't, like Germany, they won't allow the growing of GM corn. But most countries are allowed to legally, and they do. And the one approved GM crop in Europe is the one that was created by Monsanto. So it's MON-A10 maize, and it's a form of BT corn, kind of like the same principle as BT eggplant. So the EU imports genetically modified soy meal and corn as animal feed. So they import animal feed that is genetically modified to feed to their animals. And then, of course, they feed on their animals. Over 14 million Western Europeans visit the United States annually. And of course, here in the United States, they eat GM food, even if unknowingly, because GM food is common here in the United States. The estimate is that 75 to 80% of all processed food in the United States contain GMO. And that includes soda, that includes crackers, that includes all kinds of food that you will find in the grocery store in the processed aisles. Now, this is breaking news. The European Parliament earlier this year in February, they voted to ease gene regulation of gene-edited crops. So this is a form of genetic modification, but they refer to them as the new genomic technologies, or NGTs, which include CRISPR, which is a genome editor. So in other words, there you can see the trend of opening up to these techniques for genetic modification of crops. And of course, in the Philippines imports a variety of genetically engineered crops with approvals for direct use, including soybeans, corn, cotton, canola, potato, rice, eggplants, and alfalfa. So a lot of these vegetables here are approved for direct human consumption, even though they're genetically modified. So you can see the inconsistency here between the decisions by the courts versus the importation of the country of this genetically modified produce. And also in terms of food aid, the Philippines is a consistent food aid recipient through the USDA Food for Progress program. For instance, genetically engineered soybean meals, and the importation of food aid commodities has been unimpeded by GE issues. So again, there is this inconsistency in terms of policies and court decisions in the United States. I believe this in the Philippines. I believe that's my last slide. So these are just topics that I would like to present to you for discussion, or to help with the discussion. Thank you. Back to you, Marge.
Thank you, Joel, for that very informative talk about GMO, not just in the Philippines, but also around the world, and how they are being developed and accepted in different areas. And so at this point, Gladys, I think we should start our discussion and entertain questions from our audience.
Yes, thank you again. Thank you very much, Dr. Emil Javier, National Scientist Emil Javier, and Joel for that wonderful and comprehensive presentation. Now, there's a question here from Carlo Cosujo Jr., and it's directed to Dr. Javier. Is there any scientific basis for the kind of monitoring that CA wants? Monitoring beyond IRM is how they put it.
Well, yeah, that's one of the issues that has been raised. The Court of Appeals conceded that the regulations are in place up to the point when these products are approved for release to consumers. But there is no monitoring of effect or impact on consumers after the food enters the food system. And so the argument there is it is assumed that all foods that have received clearance from the Food and Drug Administration will now be under the scrutiny of the various agencies of government. The Department of Health, they would certainly look if there are cases of poisoning or allergy. The Department of Trade and Industry, and so forth and so on. So all over the world, I do not recall if there are provisions for monitoring of specific foods after they're released into commerce. So I think that's one argument that is beyond the remit of the regulators, because the food now, they have done their due diligence. They say the food are as safe as the conventional. And so when it gets to the food system, the rest of the government machinery takes over. So I think let's go over the regulations all over the world and point out that there is no such thing as monitoring of GE crops on consumers after they join to the food system.
Right. Marge, can I just ask Dr. Javier a quick question for follow-up, please?
Sure. Go ahead.
Yeah.
Joel.
So, Dr. Javier, the two major concerns, of course, with GE crops during the testing period is to make sure that they don't produce toxins, and to make sure that they don't produce allergens. Now, because I'm not familiar with the regulatory testing of genetically modified crops in the Philippines, I presume, but please confirm whether that includes the verification of those two things, that there's no toxins and there's no allergens.
Well, in fact, all these general statements you made, Joel, were entered by our lawyers. But for some
Okay.
reason, for example, we call out that since 1996, when GM corn was first commercialized, and up to now, more than 2 billion hectares of those GMO crops have been harvested and eaten by people and livestock, and no single
right.
instance of allergy and
Exactly.
poisoning. But for some
Exactly.
reason, our honorable justices would listen to Masipag and Greenpeace and oppositors and sort of
Right.
ignore our contention that in fact
Yeah.
there's no such thing. For example, if I may, in the deliberation, the expert witness of the opposition, a rural doctor, made a very important assertion that there was an exponential rise of skin diseases in San Mateo, Isabela, where since they started GMO corn, as well as reproductive problems among women.
Okay.
But our justices did not ask, were there other similar observations by other doctors in the rest of Isabela? There are 30 towns in Isabela who
Yes.
are also growing GM corn.
Right.
They didn't, our justices don't have enough background in biology, in
Exactly.
statistics. They should have asked, how about in Pangasinan? How about in Bukidnon, in South Cotabato, all those places?
Right.
And
Yeah,
then
yeah.
2.5 billion hectares have been harvested since 1996.
Yes, yes, yes.
So
And that observation, if I may, was just correlation. That's not causation.
Right.
yeah.
Yeah.
So,
All
so
right.
if there was that exponential increase in skin diseases, the Department of Health should have noticed that there is an epidemic of skin diseases in Isabela, but there was none. But our
Right.
justices did not ask, and that
Yeah.
that procedure did not allow. Maybe our OSG, our lawyers, government should have asked, but maybe I don't know if they are allowed to ask in that hot tubbing method of court proceedings.
And one just quick interjection, please, and then we can go to the audience. And that is why it's really critical for going forward in the future for a law to be established addressing how to evaluate and how to establish the parameters for establishing and evaluating the safety of GMOs. Because the Supreme Court, I mean, the court justices, they don't have the expertise to do the evaluation themselves. And I don't think that they're willing to do that actually, but they're helpless. There's nothing in front of them that they could use as basis legally for evaluating what's in front of them. So they just invoke the writ of kalikasan as an easy way out for them, if you will. So anyway, you just emphasized that, Dr. Javier, that there's a need in the future to have a law that should be established on this. Thank you.
Very good point, Dr. Emil, Javier, and Joel. So we have two raised hands here. Marge, so let's start with Al Serafika, and then we follow
Yes.
Dr. Billy. Al, you have the floor. You're muted.
Al, you're muted.
Okay, there you go. Thanks. I'm being unmuted by Fred actually. There's two items. I mean, one item that resounded to me is actually from Joel's presentation on regulation, the FDA. I was under FDA for 17 years in the US for medical devices. And we had such a thing as what we call post-market surveillance required for us that produce regulated products like a medical device implant. So I figured the question of the gentleman earlier regarding post-market monitoring, in our case, it's just reporting adverse events when they happen and duly investigation indeed whether we are causing the adverse event in that parameter. As again, Joel mentioned, causation is not correlation is not causation in this case. So clearly, maybe a law indeed or a regulatory reference to the FDA based or the requirements from the BSP requiring to just report any untoward incident would be enough to address that requirement for post-market surveillance or monitoring with parallel with other regulated products like drugs and devices. But the other question that I have for national scientist Emil, Javier, is did we actually do economic impact of such decisions in way of both the cost of manufacture in comparison with the regular PT talong and golden rice or infused with vitamin A, which is equivalent to golden rice? Would that have a bearing in the courts, both economic cost reduction in the use of GMOs, which would be for GMOs, obviously, and the other aspect of the market benefit? Indeed, safety is very indicated by Joel's presentation, having tons and millions of hectares being produced and no untoward incident to it. But more on the economic aspect to our markets in the Philippines, Doc Emil, in terms of by disallowing this, it would raise the prices of talong and the cost of manufacture of talong and gold and infused vitamin A rice that would impact the consumers by X amount and increase the food insecurity aspect of our country, thereby making it a national concern. So that's my question. Is there an economic argument to be had in order to turn the minds of these justices, of the honorable court? My dad is in the court house as a lawyer, but the honorable court to sway their decision making that whatever they did or whatever they just did has an economic impact and potentially a national health concern because of inadequacy now of supply or increase in prices, making it not affordable for people to have increased food security.
Yes, there was a submission of a research by Dr. Cesar Kikoy of the Ag Economics Department at LB, where he showed studies on DT eggplant, the tonnage of marketable fruits versus those which are thrown away, and therefore the economic yield and income of farmers with more fruit being marketable, as well as the reduction in cost of pesticide. Of course, I don't think he gave a value of how many lives and the value of those lives that have been saved for not using pesticide. But there was a detailed study by Cesar Kikoy.
Okay.
So it's not that the courts did not receive those kinds of statements.
Yeah.
But anyway, let me go back to your first part, Al. Very important yan. That the issue of the Court of Appeals was the monitoring after the food gets into the system.
Yes.
And then our regulator says we had none. But the argument is because the assessment of food is now under the purview of all departments. And I think it's very important that the mode of assessment is by adverse reports.
Correct. There is actually the answer that you're saying that we had none is incorrect. Because what you're saying...
Kaya mali ang sagot ng ano natin yung ating mga regulator.
Exactly.
We're just being frank, wala. But in fact, as you were saying, the idea is the monitoring comes in the form of hindi yung everybody is being surveyed, ano nangyari sa inyo, but by adverse report. So dapat kasama yun, our lawyers should make that point. That's how it's being done all over the world.
Correct.
Right.
Monitoring by way of adverse report rather than specifically surveying how much talong did you eat today and so forth. So,
Yes.
tama, Al. Dapat yun. Dapat malaman ng mga abogado natin yun.
Sige.
Right.
Dadagdag natin yan, guys.
Yes,
I
Emil,
just want to Yeah, I just
Sure,
want to add
Joe.
one quick thing. So with regard to BT eggplant, Bangladesh is a country that has really embraced the growing of BT eggplant, and they're producing tons and tons of it in Bangladesh over many years now. And I've seen reports actually where and I need to provide you with copies of those, and I haven't read the reports, but it's a success story for them in terms of safety, in terms of economics as well, because as Dr. Javier mentioned, they save tremendously on pesticides because they don't need the pesticides that they used to apply on the native variety of eggplant. So there's this well-documented case study on the part of Bangladesh.
Well, you know, they had an expert witness from Bangladesh who's disparaged the BT eggplant in Bangladesh. But counterfactual was the statements of the Bureau, the Bangladesh Agriculture Research Institute and Department of Agriculture of the number of takers, the volume, and then the economic benefits out of the use of BT eggplant in Bangladesh since so many years ago. But apparently, the justices gave more weight to the statement of this expert witness from Bangladesh, claiming all those kinds of things against the official report of numbers of users, the benefits, income, and so forth and so on, as reported by government. Naging, it's not that the justice did not get to know that those kinds of information, except that they gave more weight to this so-called expert witness from Bangladesh against the statements of even our own experience with our research on BT eggplant, which are sister lines, more or less, of those in Bangladesh.
Okay, thank you very much for that. Should we call on Dr. Cabellon Jr.,
Yes.
who's raising his hand? Please unmute, Sir Billy.
Please
Okay,
unmute.
now I'm muted.
Okay, unmuted
Oh,
na.
thank you very much, Madam Vice President, for the floor. I was very intrigued with the preciseness for definitions, especially from the eminent president of the University of the Philippines, President Javier. I know him as President Javier. And also, I was also very intrigued with the precise wordings that Dr. Cuello was trying to emphasize. So I begin with that because item number 7 of the ruling of the Court of Appeals enjoins or requires the Joint Department Circular to specifically monitor these activities regarding GMO, to specifically monitor the activities of GMO. As I read through the Joint Department Circular, and the justices also pointed it out, that there are no specific, precise criteria for monitoring. Hindi lang, oh, kumusta dyan? Wala bang may sakit ng galis? Or ganon-ganon. There are no, from a scientific point of view, there are no published criteria as to what is safe. So I go to Dr. Cuello. Okay, the Europeans have had this, it is safe. So I go to the definition as to what constitutes safe, and will it be a challenge to this scientific forum? By the way, I have to mention that all the scientists are here in Washington, D.C., including Dr. Gisela Concepcion, because we have a meeting they have a meeting here, and tomorrow I'll have to drive them to the Walter Reed Army Institute of Research. So all of the scientists of the Philippines are here. So that is my question: is does the scientific community of the Philippines have can they publish the requirements from a scientific point of view as to what will be monitored? Thank you. Thank you very much.
Well, okay, that's the contention of the justices. They conceded that the assessments were robust up to the point when the product is deemed safe and comparable, or no riskier than the conventional counterpart. But there is no such formal process of assessment where they trace the product as it goes through the food system. Yun ang hinahanap ng justices of the Court of Appeals. And our regulator says, very honestly, they didn't have such procedures, robust procedures, compared with monitoring insect resistance. So that's the main weakness that they pointed out on why the JDC circular was not enough, that there was no monitoring of what happens to the people or the consumers when these products get into the market. But their argument is, globally, that's how it's being done. That as soon as the regulatory system does its due diligence, it's assumed, and they have come to the scientific conclusion that they are no riskier than the regular counterpart. Then the monitoring is now taken over by the Department of Health, Department of Environment, Trade and Industry in all its aspects. And as Al was pointing out, the monitoring is in the sense of adverse report and then investigation of their adverse report. And that's how apparently it goes in other countries and even in the Philippines. So in ang bone of contention, what would be the detail of monitoring that would satisfy the justices after the product gets into the food system, comparable with what's being done all over the world?
Right. If I may add to that, Dr. Cabellion, so here in the United States, with the Food and Drug Administration, the focus of the testing is on the evaluation of the protein product of the gene that's been inserted into the GMO. So they have to evaluate whether this foreign protein to the organism in question is, when consumed by humans, would that pose a risk as an allergen? And number two, would that pose a threat or a threat as a toxin as well? So those are the focal points for the assessment of the risks of GMO during testing. And to my knowledge, and anyone can correct me if I'm wrong, but here in the United States, there is no human trials required for evaluating the safety, biosafety of GMO crops during the testing period. Yes.
But Joel, the sponsoring company, manufacturer, or the plant breeding institution itself has its due diligence. You test for known allergens, because your product will have no market if from the very beginning.
Correct, exactly.
There are already known allergens in your product. So you systematically get rid of them. Worse if they are toxins. So,
yes, that's an excellent point. Yes, made by Dr. Javier.
Because
so in the process,
not only will you have no market, you'll have product liabilities, lawsuits, if you have a known allergen in your product or toxin. Anyway,
That's
that's
right.
the main contention now, and we that's the issue of to what extent what kind of monitoring is practical and what would satisfy requirements of the judicial system.
Can I just also ask this question? Let's continue this conversation. So Joel, you mentioned that there's no human trials even here in the States, and so Dr. National Scientist Dr. Emil, Javier, is there also you mentioned that UPLB did some testing. Did they only do it for in vivo studies? Did we do human clinical trials for the BT talong or golden rice?
I don't think so. There was none, but there was a feeding trial on golden rice.
I see.
Yeah,
Yes.
but no feeding trials on BT eggplant.
Right, right.
Okay.
And I should quickly add, Gladys, that here in the United States, private companies on their own, before they seek for the FDA approval to test for toxins and even for allergens, they use animal models
Exactly.
for verification. Yeah, not human trials, but animal trials. Yeah.
Okay,
Yeah, I would
good.
think that it would at least go through animal models before it's deployed
Yes.
into humans. Yeah.
Exactly.
Yes, because I'm working on functional food development, and so yes, we also do that. We submitted for cytotoxicity studies using in vivo experiments, and then but at the same time, the requirement now is to do efficacy studies to humans. After that, after showing that it's safe, so you test for stability and then cytotoxicity, doing in vivo studies. But the next step that they require, say for example, if you submit your proposal, the next step is to do efficacy studies towards humans. So that's the requirement here, but I'm not sure.
That is quite interesting, Gladys. If I could have a quick follow-up. So you're working with functional foods that are natural, or are these genetically modified?
No, these not natural, not GMO.
And they are requiring you to go through these trials.
I think so, because that's the next step that they want us to show.
That's
They
very
must
interesting.
probably do that for the GMO. It should be probably even more important to do that on the GMOs. Yes.
Yeah. Yeah.
Anyways,
Okay,
there
we
are
have a
ones, yes.
question from Benigno Pexon. Please show yourself on the camera.
Thank you, Dr. Pexon.
Thank you for the.
Pexon?
Can you hear me now?
Yes, yes.
Yeah, my sinabi ni Emil. By the way, excellent presentations. Dr. Javier said all their GMO crops will be affected, will be covered by this CA decision. It's great that people try to get a law, but we all know it takes forever and takes years to be able to pass a law. Since the law, this decision affects the prices of food, and one of the drivers of inflation in the Philippines are food prices. Emil, can we craft instead an executive order from the president through the proper agency, maybe the NEDA? How can we reduce food prices by allowing GMOs? Al Serapica mentioned about the economic aspects. The easiest way is through executive order. Maybe that's a route we haven't examined yet. Thank you.
Ben, in the decision of the Court of Appeals, number 7, the first 6 had dealt with golden rice and BT eggplant. Number 7 is an omnibus statement on all GMOs. And in my dialogue with the poultry and livestock people, I said, you have a problem. Because in plain English, number 7 says all GMOs. That includes your GM corn and soybean meal.
Exactly.
But of course, the argument said, but we are not parties to this case. So the legal argument is you cannot rule on us because only the eggplant people and the golden rice people were implemented. We were not parties to this case. But I said, but in plain English, if the intention was to exempt soybean and corn, they should have enumerated that number 7 ruling applies to all GMOs except rice, except corn and soybean. So they are now very frantic, and they're reaching out to Secretary Laurel and the president, because if that number 7 decision of the Court of Appeals will be implemented, then they will have problems, because the Bureau Plant Industry person now says that he will not process GM corn and GM soybean because he might be cited in contempt of court. And if I were that BPI guy, I would do the same to save my neck, because in plain English, it says all. So I will not process any import of corn and maize. So they're elevating it all the way to the president, Ben. I don't know how
That's the way
it
to
will
do
work
it.
out.
That's the way to do it. We need an
Because that
executive
will
order.
collapse. That will be a collapse of the livestock industry in the Philippines
Yeah,
in no
right.
time.
Yes.
So that's how absurd some of those rulings could be.
Okay, Giselle, would you like to ask your question now?
Yes, Giselle.
Thank you. Yeah. I'd like to thank NS Emil, Javier, and Dr. Joel for your excellent presentations and all the interventions and questions of our participants. This is like a deja vu to me, because when this issue first erupted in 2016, I was a VPAA, and I had to issue a statement when Greenpeace and other NGOs had pulled out our plantings in the field trials in UP Mindanao and UP Los Baños. And with me making a statement at that time was a UP law professor who had a molecular biology background. And this person is now the chancellor of UP Diliman. So if we were to move forward, I understand that after this fireside chat, there is a plan by President Gladys to come up with a position paper to present to maybe a Court of Appeals and offer ourselves as amicus curiae, perhaps to the Supreme Court, and also to the executive branch of government. I think that we should really argue from the basis of the science, which we would know, and then all the way to the economics of it. Let me start with the economics, because it happened in 2016 that together it was like omnibus. The ruling banned the use of all GM products, and so that meant that the importation of all the BT corn that were required for the livestock industry, those were banned, and that was the immediate or real reason why the decision was reversed. Okay, so we are in a similar situation now, but maybe it's even more serious. Let me just say that for the BT products, which include not only talong, but also worldwide soya and tomato, BT tomato, we are the recipients of products. We import a lot of products with a lot of BT products of soya, like Europe is receiving now, of course, corn, and even tomato paste. Okay, but in our case, we focus on BT talong because we know that talong, eggplant, is a very nutritious and cheap source of macro and micronutrients, and that is why UP Los Baños focused on it. Now, I just like to go back to the basics of BT. So Bacillus thuringiensis is actually it's a naturally occurring bacterium. So it's in nature, and it's there actually to balance predators and prey. And so this bacterium is toxic to some nematodes, worms, and also to beetles, insects. And one of our PAASE members, this is Gus, Augustine Daronila, who is in Melbourne. He did his master's or dissertation thesis on BT. And he had already shared with us in some previous webinar that as part of their experiments, they were actually eating the BT, bacillus. It is a natural bioinsecticide. Now, what is this new technology of GMO? It's just to get the genes responsible for the synthesis of the toxin, a particular toxin that is toxic specifically to the gut of the fruit stem borer, okay, say the insect, the bee. And it's been shown not to be toxic to human gut, okay? So it's no wonder, like Joel shared with us, worldwide GM, BT products are considered safe, And our livestock are really fed by BT corn. So I don't think there should be a big problem with the BT products, especially BT long, so important for our nutrition, okay? Very cheap source of good nutrition. So the other product is the beta-carotene, golden rice, which is a little bit more controversial. And as Dr. Billy pointed out, the issue would always have to be with biosafety for health. And the issues for health would be allergy and toxicity. So in the case of BT, I already explained, there's no toxicity because it's very specific to the gut of the FSB, the fruit stem borer. Okay, but in the case of golden rice, there's actually an ongoing debate because we know that vitamin A, beta carotene at excessive levels, and I think Dr. Billy would know this, could be toxic, has toxic effects. And if you had incorporated it in rice, and so it's golden rice, and you want to feed it to children, and the reason it is motivation for this was really to reduce the incidence of blindness in children, you know, problems with vision, then you'd have to probably regulate the amount of rice that will be taken, because in the reports that I just read some of them, it produces, the golden rice has 23 times more vitamin A. So 23 times more of what I wasn't able to get that, okay? So that's the first, the toxicity. We know what toxicities are associated with vitamin A. The second is allergy. And we know that fat-soluble vitamins, like vitamin A, tend to have more allergies. So moving forward, how would we then help, the regulatory, in terms of doing the field trials or the, you might say, the clinical trials to monitor these adverse effects on health? I think that's where we should try to look at how it's been done in other countries. And Joel already and Marge already explained to us how this is done. Okay. And so we would just perhaps propose to try it for a municipality or an LGU that is cooperative, where the health officers, the doctors are more understanding of science. You know, they understand the science behind biotechnology. So we cannot solve the problem on the national level in terms of trying to get to the communities to accept biotechnological food products. We have to do it with selected communities, with the help of the medical community. Okay. Now, the other major concern for all of these is environmental, the wreath of kalikasan. And I must say that some of our respected scientists, including in UPLB and in Silliman University, are champions of wreath of kalikasan. It's a different level of science, environmental science, as they know it or they knew it. And I don't know, Dr. Javier, if I should mention a name of one of your champions of environmental science, who's also in biotechnology, but the other one is a famous person from Silliman University. But anyway, that's maybe also something that should be well addressed by PAASE. And well, this is the first forum that I have attended, but we have received, the notices from government agencies to get the opinions of NAST and the NRCP on this issue. So I think that for the environment, the concern is how are you going to control what would happen when there is crossbreeding or seeds that are wind blown and they have the surrounding areas that are not really planted with the GMO, and then suddenly they're also in the they're also becoming a GMO. So I think this is a real life problem that is worth the while of the PAASE as well as the NAST and the NRCP, where I'm now involved. And at our meeting tomorrow, Dr. Cabellon, we are hoping that with officials not only from the DOST there, but also the NAST president being present, and I'm serving as an NRCP Vice-President at present time, and the executive director will also be there. Perhaps we could gather in unison to come up with a very powerful and purposive position that would be useful to the executive branch of government. Maybe that's easier, as Ben proposed to National Scientist EJ, and so then to the judiciary as well. And I would immediately reach out to Chancellor Carlos Vistan, who has a molecular biology background and is a legal luminary, former dean of College of Law, to help us with this. Thank you.
Okay. Thank you, Giselle.
Thank you
I
for
think
the
that actually dovetails with one of the questions on the chat box from Gina Ray Pagaduan. Can GM crops hybridize with native crops, such as GM rice with heirloom rice? And if yes, are there established protocols to prevent this? I guess first, what's the impact, and then,
Let me take a crack at that. Giselle mentioned so many things, but yung environment, threat to the environment, I think we have to look at the specifics. The problem, part of the problem is, as Joel alluded to, is when you assess risk, you don't assess risk in absolute terms. You must assess the risk of a product, a new product, against the old or the existing practice. So, for example, in BT eggplant, between a known poison versus maybe a poison, then you should know how to decide, because clearly the current practice is spraying almost every other day of pesticides on eggplant. In fact, tinutubog pa nga yun eh. That's why I stopped growing eggplant, because my boys were starting to do that. So you have to, when you look at the comparison, should be the existing, the new product versus the old, the GMO but non-GMO. In terms of environment, for example, the carotene genes transferred from corn to rice, and supposing rice breeds with other genera of grasses, which is very unlikely. So what's the deal? So all those weed seeds will have plenty of carotene. And so the Maya who eat the weed seeds will have very bright eyes. So anong problema natin? With more Mayas, they will eat all the insects that are destroying our crops. Now, ang problema is you already made a judgment that when there is cross-pollination, there is contamination. Loaded yung word na contamination, that means already pejorative. So if the weed seeds have more carotene in them, is that necessarily bad? Maybe not. So, and also you're talking of one gene, and there are 10,000s of genes. And then you're imagining that one gene will, for example, make a super weed. You know, supposing you have more carotene, will that make rice a super weed? What kind of causality can we invoke? So we have to very, very specific, rather than, this exchange of genes. But you see, exchange of genes happens all the time
Mhm.
by sexual means and other means. So that's the nature. That's how species evolve. So we have to really look at those allegations and really pin them down rather than just generalization. Giselle, last point, yung golden rice. That's what the strategy had been along. So peel rice had been growing hundreds of golden rice hectares already in specific communities where the local governments and the local communities welcome the benefits from golden rice. There are already hundreds of hectares, but with this ruling, suddenly that stopped. So I don't know, because we promised that we will buy back all those golden rice from the seed growers and mill them, and then have all these tests of rice quality and so forth and so on. So all of that are now in limbo. But that's precisely what PLS had been doing. They selected, or they went to the communities and grew all this seed increase of golden rice only in those local governments where the local officials and communities welcome golden rice. Yung problema ngayon, what do we do now with the hundreds of tons of golden rice now in the hands of those seed growers? I don't know how the Department of Agriculture will now proceed, because we promised we will buy back all those golden rice seeds. But the last point, matatapos na tayo. Another very serious objection of the Court of Appeals is the infirmity of the JDC, because it did not provide for mandatory labeling of GMOs.
Mhm.
You know, because you have the right to know, but labeling mandatory is also will cost a lot of money. So that's something that has to be looked into, whether in fact the regulator should have the right to impose on mandatory labeling, or should that be another law by Congress? Because mandatory labeling, if they're of known allergens, I think no. Well, okay, if I were asked if they are known allergens, then we should really label. But in the case of golden rice and BT corn, there are no allergens. Why should there be mandatory labeling? Because it will cost, as a general rule on GMOs, mandatory labeling will cost money. So in the US, of course, because it makes business sense for some, they label their products on their own as non-GMO because they'll make more money. They raise the price and they have more market. Ewan ko kung totoo doon. Even salt now is claimed to be non-GMO. Okay, anyway, that is an aside, but that is an issue that we have to look into, whether in fact the JDC, the regulators have that authority to order mandatory labeling, or whether it's in our economic interest for mandatory labeling, or that should be a separate debate in Congress on a law on mandatory labeling of GMO. But that's something that we have to look into.
Right. I just have a quick comment on Giselle and a quick question to Dr. Javier, please. Giselle, thank you for all of your comments. They're very helpful. But just one quick comment about the writ of kalikasan. I think I speak for everyone at PAASE and even NAS that the way that it's written as a vision statement, as an aspirational statement, I think we're all for it. We all agree with what's contained in the statement of the writ of kalikasan. But the way it's written as a legal benchmark, as a legal criteria, that's where we are not happy with it, because it's not written in a manner that it is an operable and a practical legal standard or benchmark, because it's unattainable the way it's written. So in its ideal and its principle, we're for it, but as a legal standard, it needs to be rewritten, basically. Dr. Javier, one quick question. In terms of the current decision by the Court of Appeals, And of course, it's addressed to the respondents. So who is the leading respondent that will be responding to the decision made by the Court of Appeals?
The two proponents, Phil Rice for golden rice and UP Los Baños for BT eggplant. But we are
Yeah.
represented by the Office of the Solicitor General, or OSG.
Okay.
So that's how it works. So the
Wonderful.
lawyers of Phil Rice and UPLB must now work together with the Office of the Solicitor General, who represents government in lawsuits.
Yes, that's right. Yeah. Oh, that's wonderful. Thank you. Thank you.
Do we
Back
want
to
to
you,
ask a que-
March.
Yeah.
Back to
There's
you.
one question in the chat that I would like to let's ask because it's been there for a while. From Maria Teresa Talavera. With the cease and desist, do we know how much our farmers are who already planted golden rice will lose? How many tons of rice will have to be discarded? And how will these farmers be protected from these losses? Again, this goes back to the economic impact.
I cited that, but I really don't know. But I know that they have planted golden rice in hundreds of hectares in so many towns. And I know that we promised that we will buy all those seeds for planting and of course some for consumption tests. So I don't know how it will turn out, but really it's unfair to those golden rice seed producers who were promised by the Bureau of Plant Industry and Phil Rice that for them to invest money and time on the production of golden rice seeds. And now with that ruling, will that include that the Rice Research Institute cannot buy back anymore those golden rice seeds which they commissioned the farmers to produce? Yun, di ko alam yun, but certainly those are the pertinent issues that need to be addressed.
Then there's another question also here in the chat box. $1 million question. Sir, how could we know if the disease is due to GMO or GM foods?
GMO or?
GM foods. I think he's referring to not GM, but
Not
GM.
genetically unmodified, the native.
Non-modified, the
Yeah.
native one. Because we don't label it, right? So how can
Yeah.
we know?
I think there was a movement in the United States actually to label GMOs so that people in the grocery store who are shopping can decide whether to get the GMOs versus not. So I'm not sure how successful it was. Joel, do you know that?
I don't think people here read the labels.
Yeah, but there was a movement to do that.
Yeah, so I think
I
that
guess we just
in
have
the United
organic
States,
versus non-organic.
right. So I think in the United States, when it comes to a primary product of a GMO, like a fresh vegetable or fruit, yeah, people tend to kind of read whether it's GMO or not. But in terms of the secondary products, like if you have flour, for instance, that flour has been used in processing certain food, I don't think that's labeled at all. And so when you buy, processed food like canned food at the grocery store, you don't know, but more than likely 70% of the time, what you purchase is actually GMO or contains GMO.
I don't think the U.S. federal government has mandated labeling of GMO. These are decisions made by companies who think it's in their business advantage to label their products as non-GMO because there is a niche market for that.
Yeah.
So it's a business decision now of the company to label themselves as non-GMO. Kaya nga ang biro ko nga to the point that they're selling salt now in the US with a non-GMO label. Pero biro lang yun siguro.
It's organic.
Right.
It's inorganic.
So there's
Non-GMO salt. Anyway, so yun ang issue din sa atin sa Pilipinas, whether we will legislate mandatory labeling of GMO. Because it will cost money to do that.
Yeah.
And for what reason? For what purpose? The right to know of some people? Yes. But just like organic and inorganic, it's nice to know, and I want to buy only organic. That's my business. But and that's the business of the producer. That to make that business decision to label the product as organic or non-organic. So the same with GMO. That's an issue that we have to address as well. Whether that would require separate legislation, or as the Court of Appeals justices mentioned, they should include the mandatory labeling as part of the regulatory process.
Al?
You're
Unmute.
muted, Al.
Okay, there, finally. I'm trying to unmute myself. In terms of labeling, Doc Emil, in the US, there's such a thing as black labeling that's required for devices that are dangerous, as well as drugs that have particular classifications as being narcotics. And the argument in GMO labeling, if I remember the last circular on that one, it cannot be mandatory because it's discriminatory in that regards unless there's evidence that you're actually going to cause harm as a warning. But if you have no known identification of a adverse event, you should not be mandatorily required to label.
Yeah, that's what I'm saying. If there is known allergen in your product, then it's all right to be required to say so. But in the case of GMO, there's no substantial proof that it has allergen and toxins in them. So it's a kind of right to know.
Yes, or in the
but it will cost.
It's the product offering. Kasi I mean, I'm following on Giselle's argument that it might have some toxic levels of certain vitamin A on golden rice. We can accommodate that, but definitely we have to go specific on the product that is being delivered to the consumer. If indeed there's a likelihood that there's an elevated amount of a particular allergen, then the warning is merited. But in the event that you're feeding, like in the case of BT corn, you're using it as feeds, and then the animal eats, and then you eat the animal or you eat the beef, unless there's known accumulation of the BT allergen in the meat that you're eating, there should be no label on the meat product that's being purchased by the consumer. So there has to be a reasoning behind the requirement of the Court of Appeals to say that unless it's merited by a known scientific or health proof that the labeling is required, then it should not be mandatory. That's my kind of, at least taking in from the regulatory standpoint on how regulators tend to mandate mandatory labeling. Only in the event of an adverse event proof or the likelihood because of high elevated concentrations that's known to cause allergenic effect, like in the case of maybe beta carotene, but definitely unless those products have those particular concentrations, it has to be, again, probably in the motion for reconsideration, which I think would be filed by the Solicitor General in this case for Court of Appeals. We need to indicate that there are remedies that's already available in the government institutions like the FDA or the DA or DNER to monitor such events that can be applied towards this particular two products as better than not saying that they have no way of monitoring it post-market or post-deployment in that regards. So it would be an MR, Doc Emil, that's going to be done.
Yeah, well, anyway, related to that, Al, you have a funny situation that one of the expert witnesses claimed that a baby has to eat hundreds of kilos of rice every day to meet the vitamin A requirement. And then the other expert says there's a real danger on vitamin A toxicity. you are how can you win that kind of argument? On one hand, one expert says you have to eat hundreds of kilos of golden rice every day, and the other one is, oh, there's a big danger of vitamin A toxicity. So the claim of our expert is with the regular amounts, that would be enough for maybe 30% of the vitamin A requirement. So yun ang nabasa ko yung huli na in the amounts that people will normally eat rice, that would be as good as maybe 30% of the vitamin A requirement. Hindi naman totoo yung expert na you need to eat hundreds of kilos of rice every day, or then you have a real danger of vitamin A toxicity. Paano ka mananalo sa argument na yun on both sides?
It could possibly be because yung vitamin E parang fat soluble, nag-accumulate sa fat, di ba? So it can go to high levels dahil hindi mo excrete like vitamin C. Yeah.
I agree.
Yeah. So but you don't eat thousands of kilos of rice to get to that level, I suppose. Okay.
So yeah, that's a recommended daily allowance for that. So I'll wrote that in the chat box. So just going back, can I think I think there's no other raise hand. Just going back to BT Talong's safety, Doc Emil Javier. So Monsanto we're actually using or buying the soybean MON 87701, and it has been identified that the gene used in BT Talong is the same as that of that soybean. It's the Cry1AC, and this has been proven to be safe. So my question is, can we also use this argument, or has this argument been already presented by the respondents before?
I think Dr. Des Hautea could answer that, and maybe that's not incriminating. But anyway, the origin of this BT Talong was Mahiko company in India had a deal with Monsanto, and Mahiko shared the technology with Bangladesh and Philippines on non-commercial terms under the auspices of Cornell University and USAID. So whether in fact it's the same cry genes or not, I cannot really say, but maybe we can ask Des Hautea, who is in the chat, na pwede ka na siguro sumagot, Des, hindi naman incriminating lang itanong whether that's the same gene or not.
Dr. Hautea, are you still there? Yeah, she is. She's still here. Yes, because we've been using this since 2012.
Yeah. Okay. The gene that we incorporated in BT eggplant is the same gene that is in BT cotton. And it's also the same gene that is in soybean. So there's a whole list of crops that has the Cry1AC gene. The Cry1AC gene is Dr. So let me just get to the whole point that Cry1AC gene has been assessed for toxicity, allergenicity, and if it is incorporated in any crop, then we also, our regulatory system also asks us to look for possible effect on nutritional composition. And so all those things, so we were talking about how do you test safety? Yeah. So you do not test safety from the statement of safe. How do you actually test, falsify safety? So you put the actual measurable endpoints. First is there has to be a problem, and then an endpoint where the risk can be assessed. And that's basically codex. So the JDC follows codex, and the requirements that are asked of BT eggplant and all other submission is actually assessed according to codex, and also the United States regulatory system for proteins, if there is protein. And so basically we presented that was in our JDC. It follows codex and also all international regulations and best practices, including OECD. So those are all enshrined in the different assessment guidelines. So we went through that. In the case specifically of Cry1AC, as I said, we actually ask the sequence that we in BT eggplant is we refer it to EPA. EPA has a database of Cry1AC, all Cry1ACs in the world. And it is in the US, it falls under GRAS.
Okay.
This is generally regarded as safe.
Recognized
That
as
means
safe.
to say, this is the reason why there is no this is declared as such because there is no minimum residue. And then if you look at that particular protein, so as I said earlier, as mentioned earlier, it does not affect mammals. It is very specific to a specific group of insect. And then
Yes, yes.
if you cook eggplant, you cannot detect it. So what is there to accumulate? So what is there to, I mean, you know, if you're trying to find like, okay, post-release, how do you do it, et cetera, et cetera. So these are the kinds of things that we all presented. So we actually asked EPA to blast it in their the one from BT eggplant, and then we got the response. And the most recent EPA declaration on PIP, or plant incorporated protein, particularly the ones that we have here, is that they will not even subject it to regulation. So that's
So it's very safe. It's safe.
yeah, because it's generally regarded as safe. It has been tested for, it's not an allergen. It has no allergenic, the only difference between BT eggplant and the non-BT counterpart is the presence of Cry1AC. And so we focused all our assessment in Cry1AC, following Codex guidelines for food and feed safety, and following Cartagena Protocol Annex 3 guidelines for environmental. So, that's basically the technical part of it. And I hope that I am not in any way being contemptuous or whatever. But as a scientist, this is basically, and this we have put it out. I am inviting everyone. We have a website that is hosted UPLB. So all information that I think it's BT eggplant PH. So please, we have a lot of resources. We have a lot of resources. It's in the College of Agriculture and Food Science website, and there's a dedicated site there for BT eggplant, and we upload all information, including published articles in peer-reviewed journals. So so we have publication in PLOS, and then also the one in Bangladesh in terms of event is exactly the same as the one in the Philippines. So they also have publication, but it's a different variety. They put it in their variety, but the event is the same.
Yeah.
So basically,
Nice
the
website.
resources that people can use. And
Yeah.
we submitted everything in court, and we asked the court to make the determination.
Right.
So,
Well, Des, thank you so much for sharing that. I think it sounded really pretty rigorous. So I'm very confident about the test that you performed.
and in Bangladesh, they have been eating it for 10 years.
Yeah.
No report.
Yeah.
Correct.
Any adverse, whether environmental or human health issues.
Yeah,
That's
that's
a
very
fact.
informative, because I was wondering what went into the testing before it was actually approved for dissemination. So this is really informative.
And then when
Yes. Yeah.
oh, sorry, following codex, when you prove, they have guidelines on allergenicity testing. So they include bioinformatics. So allergen online, so we blast everything and toxicity. So we have informatics, and then if there's a need to, it's a weight of evidence approach, and that it's all,
Right.
written up in codex, and that's what we follow. I mean, the JDC follows, and that's what they ask us to comply with. And I
Right.
believe we did.
Yes, please share with PAASE the link for that website that
Yes,
you
I'm
referred to.
actually looking at it. It's a very comprehensive
So-
website. Yes.
And then also, Doc Javier and Doc Hautea, if you want us to co-sponsor webinars about BTs, not just BT Talong, but all other
Yeah.
BT
The
GMOs,
extent.
just to re-educate people about GMOs, we can do that. We can have a series
Right.
of small webinars, short webinars about it.
Yeah, and
Just let
also,
us know.
people should know that we have a regulatory system that's based on, international accepted standards, and
Practices.
and the people who actually do the risk assessment are trained. It's not
Right,
just
right.
we pick somebody. There is actually a training for doing the risk assessment. It's not
Yeah.
just because you are an expert on this. They'll give you something, you know how it is. So there's a very different context when you're doing risk assessment, even if you have the same expertise. You look at it from a different prism, because the guidelines is set by legal terms. So I guess.
Right.
Yeah.
Okay.
But I would like, I said that I will not speak, but I think it will not be, I will not be faulted by the court for thanking PAASE, for hosting this this information. I think this is good for everyone to understand, what we're a third world country, but I always believe that we have a first world regulatory system
Yes.
and
Yeah.
local experts.
I think that's very
Yes.
good to know, so that people don't just assume that, you created the plant and gave it out there, but there's really rigorous testing that goes into assessing it and all of these allergens and effects before it is given out to the public. I think we should emphasize that.
Yeah, and I think also there's a misconception that it only takes 40 days to approve the commercial propagation. That is the last part. But before you get to that part, I spent 20 years building it from the very beginning. Our regulatory system is actually to me, is the way we implement a precautionary approach. Nothing goes into the Philippines without going through the different stages. And you can get from one stage to the other if you have not satisfied the previous one. So I think everyone in the regulatory world understands that it is step by step. That is one of the first important principle of risk assessment. And so I think if you look at the totality of see, then it embodies the principle of precaution. And you don't get to the next step if you don't satisfy the evidences that the first step requires. And I think that sometimes that's lost in the whole argument. They see only the last part, which is 40 days. It's not 40 days. In the case of eggplant, it took us 20 years.
Okay. So it's getting late. So shall we do our closing now?
Yes, hold on. One more question for Dr. Hautea. You mentioned that since the same BT eggplant has been used in Bangladesh for 10 years, why can't the Philippine court also consider this as additional proof that our BT talong is safe?
We also presented all the studies, because a lot of the studies in Bangladesh are actually published in peer-reviewed journals.
Okay.
So, and then the report of the government is basically on adoption. So they started the first year that they planted it, it's 20 farmers. Now it's more than 6,000. in less than 10 years. So adoption, if it is really bad, then why the data is showing that, and that's what the government is presenting. But in terms of scientific, during all those 10 years, there are scientific studies that are done, including socioeconomic, that were all published in peer-reviewed journal. So maybe I can also I'll ask if we can also think or upload it in our website so that people will be able to find those links and see for themselves. So yeah.
So maybe, yeah, right now we have the panelists are with us. Can you please may I request Joel and Dr. Emil Javier to please smile for our photo op? So that, because I will include this in our newsletter. Okay, smile. Thank you. And now we would like to request the participants if you would like to open your videos so that we can take a picture as well. And then we also have the evaluation link in the chat box. If you would like to have a certificate of attendance for Fireside Chat, please go to this link. All right, Sino. Feb, can you do the honors, please? For those who please open your videos.
1, 2, 3, smile.
Yes, thank you, Ma'am Nolly. Okay, a lot of attendees, really. So 143 attendees for this Fireside Chat. Okay, thank you.
Actually, it's 168 at the highest level. Yeah,
And then
so thank you all for attending.
Yes.
One
Yes,
request, could Dr. Javier and I make some quick closing comments or statement, please?
Sure, yes.
Sure.
Dr. Javier, you first.
Okay. I'm the incurable optimist, and so
Yes.
I'm confident we will prevail.
Yes.
And I take it from the statement of no less than Senior Associate Justice Maribek Leonen. They should not have acted on their application for the writ in the first place on the BT eggplant, because that will stop further elucidation on and movement of science on the subject matter. And I think that will be the prevailing sentiment in the courts. Of course, there will be some exceptions, but I think we will prevail. And second is, I think we should really prepare our regulators on how to answer in court. Medyo hindi tayo rehearsing, we should be rehearsing. Then, of course, we became complacent after we won the reversal. And so now we shaken up, so we have to really redouble our efforts. And finally, what kind of legislation? Kasi the Supreme Court took it upon itself to invent the writ of kalikasan because the constitutional provision was not operable. So kailangan nun ni batas. So since there was none, so they invented the writ of kalikasan and claimed this is the first in the world over. And that's correct. So dapat siguro pag-aralan natin anong specific legislation and how do you now interpret the writ of kalikasan, because it's there, nandiyan na yon. So I think dapat yun ang ating pagtuunan. And then specifically the two issues ng mandatory labeling and then post-release monitoring.
Right.
And then, but finally, bago ko malimutan, I would like to thank my associate Rhea Lee for spending overnight last night, because on short notice, I told her to prepare my PowerPoint presentation. Thank you, Rhea. Thank you, and good evening and good morning to everybody.
Okay, good evening.
Yes.
Joel?
So my first comment is I want to echo and definitely support what Dr. Javier articulated in terms of a need for a law to be legislated in the Philippines concerning the evaluation of future GMOs, so that the Supreme Court or the Court of Appeals will not be invoking, by reflex almost, the writ of kalikasan, which is awfully hard to overcome. But I share the optimism of Dr. Javier, knowing more today in this through this roundtable about the facts of the case and the history. I share his optimism that this can be overcome. Second is, I'm not a lawyer, but I think this is the second time, at least for BT eggplant, for the writ of kalikasan to be applied. And I think that's a case of double jeopardy. And so I would like to check with the lawyers, perhaps explore this, whether that's allowable in the Philippines, because I think double jeopardy is also constitutionally not allowed in the
Yeah.
So anyway, that's something to explore. Maybe this is the first time for Golden Rice, but for BT Talong, I think this is the second time, if I'm not mistaken. And I would like to echo again what Dr. Javier said earlier about the public outreach. There is a need for the public to be educated about what GMO is and what it entails and its biosafety. I think culturally, we need to influence the public in terms of how to frame their thinking about GMOs in an objective scientific way so that the public can be scientifically and fairly informed. Thank you.
Yes.
Thank you very much. So I have one more question about the position paper that PAASE is trying to compose. So once we have this position paper, I know that we have to, the motion for reconsideration should be filed by May 6th. So we would like to really have our position paper available before that time. So where do we submit it, Dr. Javier, our position paper to support for the motion of reconsideration?
Well, either you submit it to the OSG or to PhilRice or to UPLB.
Okay, all right.
Any one of those two. But very importantly, make a public statement that the PAASE as a eminent body of expert Filipinos, both here and abroad, think this way on GMO. Dapat meron tayong separate press release. But the written part, especially yung yung sinabi ni Al na yung how do you monitor after post-release, dapat yun ma-argue ng mga abogado natin. So share it with the OSG or UPLB or PhilRice, but let's have a formal public statement as PAASE. In the same manner that the National Academy has one, the Coalition for Agriculture Modernization has one, but Ben siguro yung Biotech Coalition should have another one, and then PAASE would have another.
Very good.
Thank you. Thank you very much.
Thank you so much. Thank you very much, Dr. Javier and Dr. Cuello, for your great contributions to this effort.
Yes.
Thank you all.
Thank you very much.
Bye for now.
Bye.
Thank you, Gladys, for the quick organization.
Yes, thank you. Yeah, we'll do. Next step, we have to write the position paper and the public.
Yeah. I took lots of notes, so yeah, from all the discussions. So yeah, okay. All right. Good night, everybody. Good morning.
Bye.
Yes. Okay. Bye. Enjoy Bukidnon, ha, Dr. Javier.
Ikaw pala taga Camp Phillips, ha?
Oh, I grew up in that place. That's my stomping grounds.
For everybody's information, we grow 30,000 hectares of pineapple in Bukidnon, mainly in Bukidnon. We are world-class company. Del Monte is a Philippine-owned company now, not US-owned company.
Yeah, it used to be US-owned.
We are world-class in terms of the scientific productivity and business competitiveness. So, Philippine agriculture is not hopeless.
It is great. Yeah.
There are aspects of our agriculture which are world-class.
I know when I was there, it was still owned by, it was started to be owned by Calpac, California Packing, and then it became Del Monte. And at some point, it was actually owned by the Lorenzos, who were my classmates. One of them was my classmate and my cousin's classmates. And then it just passed on to other hands.
It's now owned by Boots Campos, the United Lab Group.
Oh, I see. Okay.
Bonifacio Global City. So it's a 100% owned by Filipinos already.
Yeah. We
Okay,
still
I'm
have a
sure
house there in the Milag, which is 3 kilometers away outside. My grandparents retired there, and the land has been passed on to us. So we have a house there that we go home for the unions. Yeah.
Okay.
Okay,
All
enjoy
right.
your stay there. Sige, Gladys,
Thank
good
you
night.
very much. Good night. And
Good night.
good morning pa naman. Thank you po ulit.
Hindi
Salamat.
pa, 11 p.m. pa lang dito.
Yes, and then for the attendees, please look at the evaluation link if you want to have the certificate of attendance. Thank you. Marge, I need your help for the composition of the position paper.
Oh, yeah. I made some notes kasi baka kailangan natin yung mga statements nila. So if you can get it started, I can put some input.
Yes, thank
Okay.
you.
Okay,
Feb,
thank you.
bye. Feb, are you still here? We should start with the draft, ano? Okay. Thank you very much. Bye now. Feb, are you still there? Can you request Joel for the PowerPoint presentation, and then can we also request a statement from him? Okay, as part of his and we will just incorporate to our position paper and our public statement. Siguro the public statement can be shorter, so we can first do that and then the position paper.
Okay po.
Thank you very much. Bye. Happy holiday.
Ay, pass pa
Bye-bye.
po kami dito. Sige po.
Okay. Bye-bye.